By way of introduction, I guess, I've been working for a couple of years at the Griffith University within the research space around climate change. I've got a long history of work on climate change issues and also had a couple of years of very challenging time working for the government, which wasn't a good fit, so I ran away pretty quickly. I came across wild law in 2009 when Peter Burden ran the first wild law conference in Australia, and I'll talk a bit more about that later. So my love affair with wild law was pretty instantaneous from the moment that I heard about it. But we come to chat with folks about some of these issues with great humility. We call Earth Jurisprudence and wild law a question, not an answer. We don't present to be experts in the field. We're just people who are passionate about the issues and really want to be part of finding solutions. So without further ado, I'll give you an overview of Earth Jurisprudence and wild law and earth laws. And then talk a little bit more in detail about rights of nature, because that was what I was asked to sort of focus on, even though it's only one small thread within the bigger fabric, I guess, of Earth Jurisprudence. And then I'd like to share with you a few slides about the movement here in Australia and around the world, which is really the exciting part of Earth Jurisprudence. It's not just another theory. And as a lawyer type, there's a lot of theories in the world, but it's really lovely when people actually get inspired by them, and it informs not just their daily practice, but the collective action they choose to be part of. So, okay. So the starting point, and an audience like this doesn't need any reminder that all of the indicators in any report you're ever going to read is unfortunately showing us that the environment is in a lot of trouble. This is a report that I often like to point to simply because, though released a few years ago now, 2,000 scientists from 95 countries concluded that more than 60% of our ecosystem services, and that's a very human-focused way of describing our natural world, but that our natural world is being degraded or used unsustainably. And I don't need to talk much about that tonight. I know that everyone in this room is very aware of the situation we're in. And I think the lovely thing about the last 60 or 70 years ago or so is if you look at the literature around the environmental movements, about changes in attitudes, humanity really is trying. There's a whole pocket of the world that's trying to find solutions in a whole range of different disciplines. Earth Jurisprudence is just one area of that, so that's, I think, an important thing. We're not sort of saying that this is the solution to all things. It's just an interesting bunch of ideas that have a particular focus on law and governance. In a nutshell, Earth Jurisprudence can be described as an emerging theory of Earth-centred law and governance, and it just suggests that we rethink our legal, political and economic systems, and that we basically turn the ship around so that all of the rules and systems that underpin our society support our beautiful planet instead of pulling it apart and destroying it. And a brief word about some of the inspiration for the idea of Earth Jurisprudence. So Thomas Berry is the guy who coined the term Earth Jurisprudence. He's passed away, but his work included a lot of cross-cultural material. He was originally a Catholic priest who then became fascinated with the history of the Earth. He worked with a mathematical cosmologist called Brian Swim to write a book called The Universe Story. And it's really beautiful, and it's actually got a couple of books aimed at children, so it's just a lovely way. He was of the view that this story and evolution of the Earth itself and the universe could act as an inspiration and a guide for humanity. It helps us understand where we come from and how we fit into the whole world. And it's quite a beautiful story, and he's trying to suggest a new narrative for humanity, and it's really lovely stuff. But the book that's particularly influential to some of us who are interested in Earth Jurisprudence is called The Great Work, Our Way into the Future. Within that, Thomas Berry really pulls apart the Western industrialised countries, and he looks at the core structures underneath our governance system: education, law, economics, corporate power. He writes really, really beautiful. It's a really, really easy read, but he really does sort of lay bare the systems and the structures that are perpetuating our attitude to the world and what we're doing to harm it. Another book that I'll talk about, which we've already seen some footage from Cormac Cullinan, and I'll talk a bit more about Thomas Berry's work, but Cormac Cullinan in 2002 took up Thomas Berry's suggestion that we look at our governance systems, that we create laws that support the Earth, and wrote Wild Law, a manifesto for Earth Justice. And in that, it's like a direct call to the legal profession to really think about its role, the place that it plays within these underpinning structures. I know there's a lot of lawyers in the room, but just a few points. I often get asked what jurisprudence actually is. For those who don't know, it's just the theory of law. And so another way to describe Earth jurisprudence is that it is really just a theory of law that's trying to implement ecological justice, which is basically fairness between all species and all life forms. Some people actually call it the legal branch of deep ecology. So if you're used to philosophy, it's a really sort of not quite accurate, but a nice simple way to describe it. So what did Berry talk about really? I'm sure most of you have seen this diagram. I love it because it's the simplest way to say this is really what Earth jurisprudence is trying to challenge. The picture on the left is how our governance systems have been created. You can point back to anthropocentrism or human-centeredness as being at the heart of Greek society and some of the Greek philosophers. You can look more recently to the Industrial Revolution. And basically the idea that the entire Earth is out there for us, that it's basically a commodity for us to carve up, own and use as we wish. Thomas Berry suggests that if you look to the universe story, to modern understandings of science and modern thoughts around eco-spirituality, it's a very different worldview. It's a worldview that places us firmly within the community of life. And his lovely term is the Earth community. So whereas most of our discourse around environmental management talks about resource management and consumption and production, an Earth jurisprudence worldview talks about the Earth community and that all of the life and non-life systems in our world are part of the same equal space. And we're interdependent and extremely dependent on one another. I'd just like to make a quick sidestep into what governance is. Some people kind of use the word without thinking about it too much. To me, Earth jurisprudence is really fascinating because it challenges all of our underpinning governance systems, and they're really the rules that we live by, the rules that we create for ourselves in any aspect of life. I often joke that governance is like the atmosphere, it's kind of everywhere all at once. It happens on a Friday night in your house, the rules about who gets to eat how many pieces of pizza. The governance systems in a tuck shop are just as important as the governance systems in a major corporation. These are the rules we create for ourselves, how we do things, how we divvy stuff up. It just got awfully complicated in the Western industrial society, where our economic systems and our political systems are extremely complicated and rule-based. So just to remind you that governance happens everywhere, and when I talk about Earth jurisprudence, I'm talking more broadly about governance. Wild law is a little bit more like the practice of law that tries to achieve or implement the principles of Earth jurisprudence. I won't go into the rest. So another question that we often get is, well, what's the difference between Earth jurisprudence and normal environmental law? The main argument that Thomas Berry and others in that space, and in fact anyone who critiques environmental law would say, is if we've got hundreds and hundreds of pieces of legislation, we have a growing number of environmental legal acts over the last 20 years, but the environment conditions continue to deteriorate, then obviously the law isn't working. And the main arguments around why the laws aren't working is that we have this underpinning structure of pro-development, pro-growth, that the earth can be used up, that it's all anthropocentric, that it's all about us within this space. And then the argument is that if we continue the way we are, all that environmental law ever does is mitigate or chip away at the bad stuff, when really what we need is to transform our entire structure so that we're being much more positive and supportive of the earth, instead of allowing development at all costs and then letting a few things happen that would perhaps make things better. I meant to mention that I flew in from Brisbane today, so I'm a Queenslander. And I think I probably live in the jurisdiction that is most representative of a pro-growth culture. With the coal mines, the coal ports and coal seam gas, it's pretty hard to argue against the fact that we have legal structures, political decision-making, planning and development laws. Everything is about supporting growth and development, and a certain definition of growth and development. And environmental laws are, one, insufficient to start with, two, being rolled back. So Queensland's a great example of several really quite progressive pieces of environmental law that aren't protecting the environment as well as it should be. So environmental law has made great gains. Anyone in the room who's a lawyer knows that particularly from the 70s, we've seen a lot of sort of modern environmental law. We've seen air and water pollution and a lot of urban living conditions improved because of some of it. But at the end of the day, we're not seeing the environment benefit from our governance systems. And before I move on, it's probably important to note that environmental law has considered ecocentrism before. Earth jurisprudence doesn't pretend to be a new thing. Christopher Stone in 1972 wrote "Should Trees Have Standing?" and there's been a lot of other literature around it. I think what's exciting for some of us about Earth Jurisprudence, as I mentioned before, is that it's actually inspiring real work, and some of that work is around the rights of nature. But before I go on to that, I'll just give a brief overview of, particularly for folks who aren't lawyers, a really simple way to think about the difference between what we currently have in Western law and governance and what Earth Jurisprudence sort of talks about, or what it says. So the first point of difference is that in our Western legal system, the highest form of authority is human law. And particularly since the Enlightenment, secular societies typically don't even have a legal system that defers to God or to other systems. Other cultures do. Our system is all about humans creating the world and the vision that suits ourselves. In contrast, in Earth Jurisprudence, Thomas Berry and Cormac Cullinan talk about the great law or the great jurisprudence. Again, it's just another term, but it's not a mystery to anyone who cares about the earth. What they're suggesting is that we are actually subject to higher laws than those of man, and that's the laws of the universe. The sheer physics and gravity of our life basically are the parameters of our world. But we truly have economic and legal systems that don't reflect that. Simple examples are EU fishing quotas that set the number of fish that can be caught at a higher level than the actual number of fish that exist. We have a lot of crazy examples. Originally, grazing law in Australia was set on certain heads, a number of stock that you could have on land, and they weren't even reflective of what was truly the carrying capacity of that area. That's a whole nother story. But just to give some small examples that, unfortunately, our history of legal system and governance structures have not been reflective of the reality of our natural world. Linked to that, I guess, is the current Western legal systems focus on supporting a pro-growth ideology. There's a lot of really interesting work under Earth Jurisprudence and Earth Democracy that looks at the power structures that actually create that. It's not always the entire human community that's responsible for the creation of our law. We know that vested interests, such as those that are wealthy and the corporate interests, have played a large part in creating some of the laws that support their own success. But the flip side of that within Earth Jurisprudence is obviously a recognition that we live within a finite planet, and then that means that we do have to live within ecological limits. So again, that's just another point of contrast. The one that's particularly interesting, I think, for tonight's conversation is the idea that property and other laws reflect the view that nature is a commodity for human use. Anyone who knows about property law in our culture is that it's really, at its essence, it's about relationships between people and what people can own. If I own this land and you come into it uninvited, I can prosecute you for trespass. If you damage or steal any of my stuff, the legal system protects my interests. If you're poor and have nothing, but you have to pop onto someone else's land to grab some fruit, our legal system will say that you're doing something wrong. So our property system is really at the crux of a lot of our problems in terms of our attitude to nature. Some people point to the Bible, the idea that God said that humans have dominion over nature. I've spoken with religious groups and some of them say that you can interpret the Bible differently. So some folks would say that you can't just point to religion as the problem, that it's really just human attitudes to the natural world. So the flip side to property law is in Earth Jurisprudence, this idea of the Earth community. It's very challenging, and implementing it in our structure is going to be challenging. But it's the idea that rather than seeing the natural world as natural resources to chop up and use up, if it's an Earth community, then it affords greater respect and a greater constraint upon what humans can and can't do. And these ideas around limits and constraints are very challenging, particularly in the West. And yeah, they're an area of extremely interesting research, including the stuff I do is around that topic, and I find it really interesting. So the next point is linked to that, of course, rights. Our legal system gives rights to human beings, and it also gives rights to a creature that's as fictional as a unicorn, which is a corporation. They have significant power, and they've actually been given so much power, they have potentially more than your average individual, because they have perpetual life. And I remember reading an article once where someone compared them to a vampire. So they don't have any feelings, they can't die, they can live forever. So corporations are given tremendous power in our culture. They have all the rights of an individual. They can take you to court for doing something against their intellectual property or against their financial interests. I love pointing to the example of Coca-Cola taking the Northern Territory government to court. because of the potential for having the container deposit legislation. But again, anyone who's familiar with this, the deconstruction of corporate power is a really big part of Earth jurisprudence, and it's a really interesting one. The flip side then is that in Earth jurisprudence, what we want to think about is how do we look after the Earth? And in our legal systems, do we need to address the balance or the imbalance between humans and the rest of the Earth community? Thomas Berry argues very strongly that the answer is yes, and that with all life and the existence of non-life systems, but essential life supporting systems, there's a right. And I'll talk in a moment about what those rights are. There's a few pieces of legislation and other examples that really nicely sum that up. And the final point, someone before was sort of wondering what wild law or Earth jurisprudence says in regard to Indigenous knowledge and Indigenous systems. I think the lovely thing about Earth jurisprudence and wild law and a lot of other deconstructions of Earth, of existing legal systems, is this idea that our legal system is very narrow. We inherited it from Europe. It's come from this pro-development culture. It excludes pluralism, particularly a common law system like Australia. If you're an Indigenous person in the territory and you've committed a crime within your own culture, it can be challenging to have that matter dealt with in your own law. You are naturally roped into the Western legal system, and that's just one example. The other ideas within wild law is encouraging diversity at all levels of human governance so that local communities can have greater power over their own ecosystems and their own well-being. So this challenging of the standardisation and particularly the high levels of governance through national laws that aren't relevant to local level, all of those ideas are really interesting. So that's by way of a really quick overview, and I feel kind of that that's not entirely adequate, but with the time available, that's probably all I can do. What I want to turn to now is just one element of Earth jurisprudence, and it's an interesting one because of two reasons. There are a number of examples of this element of Earth jurisprudence in actual law, but also it can be really contentious, and it can open up some very interesting conversations over your cocktails and dinner. So the idea of rights of nature, which I'll talk about in a moment with a couple more examples, but in the USA since 2002, a really cool group called Community Environmental Legal Defence Fund has been working with local communities to use rights of nature as an organising strategy, particularly to fend off unwanted corporate developments like fracking or CSG and a whole range of other issues. There are now 36 local ordinances in the US, and only a couple of weeks ago Santa Monica City Council actually introduced a Bill of Sustainability Rights. They've been working on that for about 3 years with the CELDF and Linda Sheehan from the Earth Law Centre in California and a few other folks, which I'll talk a bit more about later in the movement. But what's really interesting about that is that they use language that tries to protect the rights of the communities to care for their ecosystems, but they also put in wording that protects the rights of nature to be defended by humans and their obligations to that. So there's also, the CELDF actually played a part in helping some of the Ecuadorian elders and the indigenous people think about the wording for their 2008 constitution. If you can hear a strange noise in the corner, that's the dog having a dream, I think. He's either is singing, which is really lovely, so cute. So Ecuador is was the first country in sort of any kind of Western system, not Western, but a modern legal system that recognises rights for nature in its constitution. I'll talk about that in a tick. And Bolivia, as the lovely lady mentioned before, in 2010, it's not a constitutional revision, but it's an actual piece of legislation that grants right to Mother Earth and has administrative structures underneath it. I'll talk about New Zealand at the end. I've got a slide on it because it's got some really interesting legal developments over there, but they're not, I often say they're kind of bubbling up from a different part of the stream. Some of these are evolving from Maori groups who are negotiating agreements under the Treaty of Waitangi. They're not coming from a sort of Berry Cullinan idea of rights of nature as such. They're a different space. So I just wanted to briefly mention the USA. The CELDF has worked with a whole bunch of groups around democracy schools, and in the US that has involved understanding their civil rights and understanding the legal structures at the local level that are available to them. What has happened is a lot of groups organise around a certain draft ordinance or a statement by the community. Mari Margle, who I've been working with on a few things, she and Thomas Lindsay have been doing all this work over there. And she was saying that the municipal laws themselves can be overridden by state and federal law, But the main thing is that there are an organising principle, they're a statement to the world about what that local community wants, and even if they're challenged, that actually helps the campaign because it actually brings to the forefront some group or company that's challenging their rights. So I just wanted to get to this point, so if anyone's dozing off, I can suggest you focus on this bit because it's the fun stuff. The actual wording around giving rights to natural communities, and this is just one example, the idea that what it says there, ecosystems and natural communities possess the right to exist and flourish within the town. The residents of the town of Wales have the inalienable right to enforce and defend those rights to protect all ecosystems, including but not limited to wetlands, etc. And also you'll see the right to self-government, rights to water, and we'll talk about rights in a tick. So a lot of those ordinances have similar wording. They often talk about the right of the natural ecosystem to exist, to thrive, evolve, and the rights of local folks to support them and to defend those rights. Someone asked before, you know, when did nature ask to have its rights defended? Of course it didn't. But when did it ask to have its well-being denuded so significantly as it has done in the last couple of hundred years? So the Ecuadorian constitution is another interesting example. Indigenous elders played a critical part, so did civil agitation or unrest to make these changes happen. And I think the wording's really lovely. Nature, or Pachamama, where life is reproduced and exists, has the right to exist, persist, maintain and regenerate its vital cycles, structure, functions and processes in evolution. And this links very directly to some of the work that Cormac Cullinan and Thomas Berry write about, which is this idea of reigning in humanity so that the rest of the natural world can continue its evolutionary journey. So it's not about environmental management, it's about managing humans so that the environment can continue and to flourish. And I love this term Cormac calls animals and plants our evolutionary companions. And I do think about that a lot. Every morning when my dog greets me and sits at my feet while I work mad and insane hours, that little dude with his little fluffy ears, he's my evolutionary companion. You know, all of us are living here today. I love that quote that popped up, you know, we're a product of 3 or 4 billion years of evolution, act like it. And I think the respect that we need to afford other species is pretty important. It's pretty much a foundation stone. So look, I could go on for days about rights of nature, and if anyone's coming to the workshop tomorrow, yeah, I thought you almost were, yeah. I've got a special prezzo on the rights of nature stuff, just so we can run through the different jurisdictions. But the Whanganui River, and I'm told that's how you pronounce it, by a trusted person from New Zealand. I'm not just going blind in my old age. This was a really interesting example, and as a lawyer I have to admit I'm kind of fascinated by the potential because the rights of nature stuff that CELDF work on is awesome, and they actually create these specific rights and they put them into these local council ordinances. But what's really interesting in New Zealand is that a lot of Maori communities are actually using Western legal constructs to protect their custodial rights and interests. And a lot of these are apparently popping up under long-term negotiations that have been happening in accordance with agreements under the Waitangi Treaty. And if anyone knows about the history in Australia, we have an absence of that kind of treaty relationship for Indigenous people, so it's a really different issue for Indigenous people here to claim some of these rights over their own traditional country. But back to this river. So it reached international media attention in August, September last year. Sometimes it was reported a little not quite accurately by saying it was all about rights of nature and that it was all done and dusted. It wasn't, it's actually still under negotiation. But what actually happened is that they're aiming to give legal identity under an agreement signed between the Maori Trust or the Maori group that are responsible for that land and the Crown. The river is going to be recognised as a person, which might sound wacky to people, but again, our magical unicorn friend, the corporation, has all of these rights. The corporation doesn't have some blobby entity that staggers into court. They're human beings standing for the interests of the corporation. And so when you grant rights to nature, it's not that mysterious. It's still human beings trying to protect nature, but they're using these sort of constructs in our legal system to give it those rights. So I've got a few more bits and pieces that I shouldn't go into, we don't have the time, but it is trying to create a structure where there's guardians of this river, that they work in perpetuity under the Maori Trust system. But there's still the agreements about what values will be protected in the river, and a whole bunch of other nuts and bolts that are apparently still being discussed. And a newfound colleague in New Zealand who is a gentleman who works on a range of different kinds of these different kinds of agreements, said that there's also a forest ecosystem that's being considered for legal personhood, and a whole range of other structures that are being considered to try to protect the environment better. For those who are interested, this doesn't exclude other people's use of that river, and there's already private properties in those spaces. So it's an interesting tension between trying to legally formalise some of these custodial responsibilities to land and also the existing structures. So to wrap up my very quick talk, it feels very, very quick, given there's so much stuff you can talk about. Does granting rights to nature create more effective environmental law? It can, but it may not. The people who advocate really strongly for rights of nature will say that given the attitudes our modern legal and governance systems have to nature and the way that we do carve them up and use them poorly, rights of nature possibly could set up a different structure where we are forced to actually re-evaluate what we do to nature and what its rights are to continue to exist. But the flip side is, like any law, how it's interpreted, administered and enforced will depend on the people that are doing that work. And if it's a rights of nature legislative, a piece of legislation within a broader culture that really doesn't care and that wants to continue just using it all up, then of course these acts may not come to much. But if it represents the beginning of different ways of looking at the world, particularly if it's reflective of grassroots up and bottom down, if everybody's concerned about this stuff and wants to make it work, then of course rights of nature can play a really important part. But if I leave you with any thought at all after this, it's that the main idea behind Earth Jurisprudence is that we need to rethink our place in the world and rethink all of our governance systems. It would just be really lovely to know that all of our systems were being turned around, tweaked on a transactional basis, tweaked at a transformational underlying institutional structure to actually nurture the Earth community. Wouldn't it be nice if everything we went to do each day was actually focusing on how we continue the beautiful pathways of evolution for all of ourselves and creatures and life forms? And that's really what Earth Jurisprudence is asking. It's asking the question, what do we have to do to become Earth-centred, to see ourselves as part of an Earth community, and to look after us and the planet better? Now, I can stop there if I've talked too long, or I can do a quick couple of slides about what's going on internationally and nationally. I'm looking around because I'm not sure who to ask. Yeah? Okay. So, wild law in Australia and around the world. As I said, my introduction to the book Wild Law and the ideas of Thomas Berry were actually only from 2009, even though his writing's been around for a really long time. Good old dog. From that, we actually, a whole bunch of us organised a conference again, and then another one. And by the time we were organising the third one, we realised we were hanging out an awful lot and that maybe we should create this space because a lot of people were interested in it. So that's what we did. We created our little organisation. Legally speaking, we're an entity that's 1 year old, but we've all been hanging out for about 3 years. So what do we get up to? Well, our vision is pretty big. It's about transforming governance systems to support the Earth. Our mission is quite humble. It's just to promote understanding of some of these ideas and to explore them in our own work, and to really explore practical implementation of what that looks like. But I guess what's equally as exciting is that we're part of a group called the Global Alliance for the Rights of Nature. It's got about 60 organisations around the world, and we're really part of a growing body of individuals and collective groups, whatever structure they take, who are interested in Earth Jurisprudence, wild law, and anything to do with Earth-centred law and governance. A number of us now are connected to Polly Higgins and her work through Ecocide. They've created an Earth Lawyers Alliance, and that's just a list of folks who are interested in these kinds of issues. AWLA itself is involved with starting alliances with groups like the Ecological Economic Society of Australia and New Zealand, and a whole bunch of other folks who are looking at how to tweak our governance systems and how to make them better. There is a website for the Global Alliance. That's just what it looks like, but the website is on our website. What else to put? So our work is all about a whole range of things. If we're a movement then our model is pretty relaxed. We don't have an organisation. We don't really plan to be a big paid up group. What we're interested in is having folks around the countryside who are interested in these ideas integrate some of it into whatever they're doing. Whether you're Lock the Gate and you want a protest sign with rights of nature on it, whether you're an academic who's already interested in these ideas and wants to continue researching and sharing and meeting with other folks, which is a big space for a lot of people, whether you're activists or people interested, students looking to do a whole bunch of other things, we really just want to create a space where people interested in these ideas can work together. We've been doing road shows around the countryside with different workshops. The workshop tomorrow was a stimulus for coming to Sydney and one of the reasons we're able to be here tonight. We're also running another conference in September. It's part Talkfest, but it's part Love-In. What we find when we do our talks and we do our workshops is that people need to find each other and to sort of nurture themselves and their interests. We do have an awful lot of fun when we get together, and we try to focus on collaborative projects, whether that be research or really practically oriented ones. This year's topic is about living with ecological limits. We've got a whole bunch of fun things happening there, including some art and a mock trial and some generally good times. And after that, and I just wanted to mention this as a final point, anyone who's interested in some of the practiced, focused stuff of rights of nature, because we're really lucky we're going to have Mari Margall and Thomas Lindsay coming over for the conference. We're also teeing up to host them for a couple of workshops in Brisbane, Sydney and Melbourne around the actual rights of nature work that they've been doing. In Brisbane, I've been connecting with Drew Hutton and the Lock the Gate Alliance, so we're going to have a really interesting day where community-based activists get a chance to have a think about what Lock the Gate's doing with its civil disobedience. So I should, and again, a longer presentation, I mentioned that Earth Jurisprudence is quite supportive of civil disobedience, and the idea that Earth Jurisprudence reflects honouring and protecting our Earth. Any laws that don't honour and protect our Earth may not be worth complying with, in which case folks like Lock the Gate are definitely doing the right thing by the Earth. They're trying to stop certain extractive practices that most would say are not healthy. So anyway, we've got these interesting workshops that are going to try to really hone in on what's the use of some of this Earth-centred campaigning for existing work, and what's the potential for having rights of nature ordinances or the equivalent thereof in Australia. And a lot of that, again, it's just open. It's like, let's just have a talk about what other people are doing and see what's relevant for Australia. That's our website. And there's a whole bunch of things going on that we'll be doing, and that's about it, I think.